Hello, welcome to the channel. My name is Vitaly Kurchin, top firearm rights lawyer in Washington State. In today's video, I'm going to discuss the recent U.S. Supreme Court's decision about protection orders and firearm rights. I will explain what the issue was, how the majority ruled, the concurring and dissenting opinions, and what all this means for the future of gun control. The issue in this case had to do with protection orders. The defendant in the case, Rahimi, had a restraining order issued against him in Texas after he assaulted his girlfriend. Under federal law, the imposition of the restraining order prohibited him from possessing a firearm. After the restraining order was issued, Rahimi went on a crime spree to include repeated incidents of firearm violence. Police eventually obtained a search warrant to search his residence, where they found several firearms and ammunition. Federal authorities charged Rahimi with possession of a firearm while subject to the restraining order, a crime that carried a maximum punishment of 15 years in prison. Rahimi pleaded guilty but reserved the right to appeal the issue of whether his prohibition on the possession of a firearm violates the Second Amendment. The case wound its way through the lower courts, and the U.S. Supreme Court ultimately decided to hear the case. The court issued 7 different opinions in this case. There was the majority opinion, written by Chief Justice Roberts, and joined by all the other justices except Justice Thomas. Justices Sotomayor, Gorsuch, Kavanaugh, Barrett, and Jackson all filed concurring opinions, and Justice Thomas filed the sole dissenting opinion. The 8-to-1 majority held that imposition of a ban on the possession of a firearm in this context did not violate the Second Amendment. Now, before I go on with explaining this specific decision, we need a flashback to 2022. In 2022, the Supreme Court issued the Bruen case, which held that when deciding a Second Amendment challenge, courts must look to the history and tradition of gun control as it existed at the time surrounding ratification of the Constitution. This means that to survive a challenge, a modern firearm regulation must have some analog in history to a regulation that existed at the time of ratification. The laws do not have to be exactly the same, but they do need to be similar. So, fast forward to now and applying this historical approach, the majority found that the protection order ban in this case has a basis in history. Specifically, the majority pointed to surety laws and going armed laws, also known as affray laws. Surety laws were a measure by which a judge or magistrate could find someone to be potentially dangerous and require them to post money as bond to assure their peaceable behavior. If the subject of the surety broke his promise, he would forfeit the money posted. The going armed or affray laws provided criminal penalties for arming oneself to the terror of the people. In other words, terrorizing the populace or inciting violence. Taking these two historical traditions together, the majority found that they were akin enough to the modern prohibition on possession, while subject to a protection order, to survive a Second Amendment challenge. In doing so, the majority emphasized 2 principles. First, that a court must make a finding that a person poses a clear threat of physical violence to another. Second, that the ban only applies temporarily while the order remains in effect. Although there were 5 different concurring opinions, they aligned by ideology. The conservative justices, comprising of Justices Gorsuch, Kavanaugh, and Barrett, issued concurring opinions to defend the historical analog approach first established in 2022 and explain the importance of relying on history to inform modern practice. On the other hand, the liberal justices Sotomayor and Jackson issued concurring opinions agreeing with the result of the case, but overall disagreeing with the historical analog approach, stressing a return to the interest balancing test used before 2022. The lone dissenter was Justice Thomas, who would have invalidated the protection order prohibition entirely. According to Justice Thomas, the surety and affray laws in effect during ratification were not sufficient historical analogs to justify the modern regulation. So what does all of this mean for the future? There are a couple of takeaways. First, the court was crystal clear that this was not a blanket ruling to approve all prohibitions on firearm rights. The court's approval of the protection order prohibition should not be taken as a sign that all prohibitions are valid. That signals an intent by the court to continue taking and deciding Second Amendment challenges in other contexts. For example, the court will soon decide whether it will hear a challenge to the federal firearm prohibition that applies after certain criminal convictions. In other words, Second Amendment litigation shows no signs of slowing down, and we can expect the court to take at least 1 or 2 Second Amendment cases each year for the foreseeable future. Second, the court made it clear that it will continue to adhere to the historical analog approach and will decide each challenge under that approach without creating any special exceptions or generalized proclamations. However, certain questions still remain. For example, while the Supreme Court approved the temporary disarming of a person subject to a protection order after a finding that the person represents a clear threat of physical violence to another, what about protection orders that are not issued for a year or 2, as in Rahimi's case, but are issued as permanent lifetime orders? It is difficult to glean what the court would do when presented with such a fact pattern, although the opinion definitely suggests that a permanent order could be found unconstitutional. Another question is, how strict is the court going to be with finding a historical analog to uphold a prohibition? According to Justice Thomas, the court's ruling in this case was already a violation of the historical analog rule because the 2 schemes it relied on were not sufficiently related to the modern regulation. These questions will have to wait for future decisions. As the court continues to mold its Second Amendment jurisprudence by taking and deciding more cases next year and in the future, this will be a very exciting area of the law to watch. I hope you found this video helpful. I did a video a while back about the 4 things you must know about protection orders. I will link that in the description below for further viewing. Thanks for watching, and I'll see you in the next one.